Very much, Mr. Chairman. Judge, I must say, I'm delighted to see your family here again, and I hope they feel that very special sense of pride in you. I'm sure they do. And I think, you know, I was thinking of my children and grandchildren, and this is really a once-in-a-lifetime occasion. So I hope they find it very special in their lives.
Thank you, Senator.
You're welcome. Yesterday, you spoke of California v. Texas, the current case seeking to strike down the Affordable Care Act. You said, I think, that the issue before the court is severability, meaning whether the court can still uphold the Affordable Care Act if it rules that the individual mandate is unconstitutional. And you said yesterday this question was not before the court. As I understand this, Chief Justice Roberts and the majority did involve the issue of severability in a case known as the NFIB, National Federation of Independent Business v. Sebelius. There, the Chief Justice and the 5-4 majority that included Justice Ginsburg struck down one part of the law, the Medicaid expansion provision, but allowed the rest of the law to stand because they found it was severable from the portion they struck down. Justice Scalia dissented from this conclusion, stated that, quote, the unconstitutionality of the individual mandate and the Medicaid expansion requires the invalidation of the Affordable Care Act's other provisions, end quote. In other words, the justice believed that the law was not severable and the entire law had to be struck down, including provisions protecting people with pre-existing conditions. You have been close to the justice's philosophy, and in these hearings, you've also said that this doesn't mean you would reach all the same conclusions. So can you explain to us today how you would disagree or agree with Justice Scalia's view of severability in that NFIB, National Federation of Independent Business case?
Well, what I think I can say without expressing disagreement or agreement for the reasons I said yesterday, not being able to grade precedents. The severability issue, first of all, the majority holding, as you recognized, was that even though the Medicaid provision was unconstitutional, it was severable. So Justice Scalia expressed his view in dissent. Even by Justice Scalia's view, the issue would be different in California versus Texas for two reasons. One, Justice Scalia thought two provisions of the Constitution were unconstitutional. So if you picture severability being like a Jenga game, it's kind of if you pull one out, can you pull it out while it all stands? Or if you pull two out, will it still stand? So Justice Scalia, his view was that if you pulled those two provisions out, could it still stand? And here we're talking about one. And also, Congress has amended the statute since NFIB versus Sebelius, and it's zeroed out the mandate. So now, California versus Texas involves a different provision because of the zeroing out that was done by amendment. So that's how the two cases present slightly different issues.
What do you think of all that?
What do I think of severability? Or
in that instance?
I think the doctrine of severability, as it's been described by the court, serves a valuable function of trying not to undo your work when you wouldn't want a court to undo your work. Severability strives to look at a statute as a whole and say, would Congress have considered this provision so vital that kind of in the Jenga game, pulling it out, Congress wouldn't want the statute anymore. So it's designed to effectuate your intent. But, severability is designed to say, well, would Congress still want the statute to stand even with this provision gone? Would Congress have still passed the same statute without it? So I think insofar as it tries to effectuate what Congress would have wanted, it's the court and Congress working hand in hand.
Thank you. That's quite a definition. I'm really impressed. Thank you. Some have argued that the Medicare program is unconstitutional well, it's an unconstitutional exercise in congressional spending power. They believe that the spending power does not exist at all. In talking about Medicare and Social Security, Professor Mike Rappaport of the University of San Diego Law wrote this: "It is worth remembering that these programs would never have taken their pernicious form if the Constitution's original meaning had been followed in the first place." Do you agree with originalists who say that the Medicare program is unconstitutional? And if so, why?
I'm not familiar with that article by Professor Rappaport, so I don't know what reasoning he advances for claiming that the spending power as exercised in things like the Medicaid provision would be unconstitutional.
Well, it's in Law and Liberty, July 23rd, 2015. But the question is, do you agree with originalists who say that the Medicare program is unconstitutional?
Well, let's see. So I think I can't answer that question in the abstract, because as we've talked about, the no hints, no forecasts, no previews rule. I also don't know what the arguments would be. So I assume Professor Rappaport lays out a case, but it's not a question that I've ever considered before. But if I did consider it, it would be in the context of an actual case or controversy.
Well, I thank you. It's hard for me to believe that that's a real question because I think the Medicare program is really sacrosanct in this country. But let me ask you, last April, in the midst of the COVID-19 pandemic, the Supreme Court prevented Wisconsin from implementing a district court order that would have extended the state's deadline for submitting absentee ballots. This would have given voters greater flexibility in casting absentee ballots for Wisconsin's primary election. Justice Ginsburg dissented. She criticized the court's majority for putting its head in the sand with regard to the risks posed by COVID-19. She emphasized that courts and election officials must be able to react to a grave, rapidly developing public health crisis. And she noted that the Supreme Court's, quote, suggestion that the current situation is not substantially different from an ordinary election boggles the mind, end quote. Would you agree, and what is your position?
Well, Senator Feinstein, that's obviously a very recent case. And, in that case, the court had to address, the constitutional question. And so, again, it's one of those things that I can't answer, both because it would be requiring me to grade and express agreement or disagreement with the Supreme Court opinion, but also it's the kind of case that could come up in a closely related form, either on the Seventh Circuit, Wisconsin is within the Seventh Circuit's jurisdiction, or on the Supreme Court.
Okay, let me try again with something. After President Trump announced your nomination to the Supreme Court, you discussed the judicial philosophy of the late Justice Antonin Scalia. Specifically, you stated, his judicial philosophy is mine. During oral arguments in the 2013 case Shelby County v. Holder, Justice Scalia questioned the strong congressional support for reenactment of the Voting Rights Act. He argued that this support was not attributable to the fact that we need the Voting Rights Act. Rather, he stated that he believed Congress reenacted the bill due to a, quote, phenomenon that's called perpetuation of racial entitlement, end quote. What is your reading of this and your understanding of the history of the Voting Rights Act?
Well, when I said that Justice Scalia's philosophy is mine too, I certainly didn't mean to say that every sentence that came out of Justice Scalia's mouth or every sentence that he wrote is one that I would agree with. When I said Justice Scalia's philosophy is mine too, what I meant is that his jurisprudential approach to text, as we've talked about originalism and textualism, is the same that I would take. And I think as for the Voting Rights Act, I think that it was obviously a triumph in the civil rights movement.
Well, the question arises in my mind. Of course, my view is that we always need this. This is a bulwark of our democracy. So need, I think, is something that may be somewhat subjective. Do you agree with that?
That need is subjective?
Yes, yeah, that I think we do need a Voting Rights Act, and it's subjective in that sense.
Well, I think Senator Feinstein, the question of how the coverage formula is calculated in the Voting Rights Act and the contours of the Voting Rights Act and whether Shelby County was rightly decided or not are all questions on which I can't give an answer because Shelby County has obviously been controversial. It's likely to be relitigated. It could come up before me on the court.
Well, let me give you, because I think this is really important because it shows the basic philosophical bent of an individual. For me, the Voting Rights Act is extremely important, and it defines our election system to a great extent. It's hard for me to understand that anyone would want to do away with it. What is your position in that regard?
As I understand Shelby County, it said that the coverage formula was outdated from the 1960s for subjecting the particular states, requiring them to get pre-clearance. It's my understanding, and I haven't looked at the case in a while, that everything else about the Voting Rights Act remained intact, including its prohibitions on discrimination in elections. It was just the coverage formula which decided which states were subject to pre-clearance.
Well, let me ask you this question, and this is a hard one. Do you agree with Justice Scalia's assertion that the Voting Rights Act is a, quote, perpetuation of racial entitlement, end quote?
Senator Feinstein, I don't obviously know what Justice Scalia was thinking when he said that. And any characterization of the Voting Rights Act or a statement like that is simply really not something I can opine on because, you know, that's tied in, I would think, with these Shelby County questions.
Well, can you opine? I'm not asking for a formal opinion, but would you believe that it's a perpetuation of racial entitlement?
Well, Senator Feinstein, I think that goes to the question of whether the coverage formula was outdated and needed to be updated from the 1960s or not. I take that to be the thrust of the disagreement in Shelby County and the position that Justice Scalia was taking. So again, I can't express a view on Shelby County and whether the majority or dissent had the better of the argument.
Okay, let me move on to workers' rights and age discrimination. In a 2019 case, Kleber v. CareFusion Corporation, you joined a majority of the Seventh Circuit judges in holding that age discrimination in employment does not protect job applicants against employment practices that have a disproportionately harmful impact on older applicants. The opinion you joined, as I understand it, dismissed a claim brought by a 58-year-old lawyer who was passed over for a job that was offered to a 29-year-old applicant with less experience. I think I'm concerned by the implications of the decision. According to AARP, approximately 35% of the United States population is now 50 years or older. Almost 29% of households are headed by someone near or past retirement age who have no savings or pension. According to the EEOC, study after study has shown age discrimination, quote, remains a significant barrier for older workers, end quote. And older applicants are more frequently denied job interviews than middle-aged applicants. Additionally, older and middle-aged women are subjected to more age discrimination than men. The EEOC has found that the Great Recession during President Bush's administration, quote, forced many older workers to revive their retirement plans, to work longer to recoup drained retirement accounts and lost savings. So here's the question, because I think it's going to be an increasing problem for the court. What do you understand to be the purpose of age discrimination, of the Age Discrimination in Employment Act?
Well, in Kleber versus Care Fusion, I joined a majority of the en banc court, so that was a case that we heard as a full court. And the question is whether the prohibition on age discrimination covered applicants or only employees. And the statute said employees, and so an applicant isn't an employee. So the majority said that the statute, by its terms, didn't cover the conduct. But I think that's an instance, I talked yesterday quite a bit about whose role it is to update statutes or extend them, and I think that's an instance in which Congress could well address this problem by amending the statute to include applicants in it.
So where would you stand on the general subject matter?
Well, since I can't impose the law of Amy, that would be up to the Congress to decide, or many state legislatures have different anti-discrimination prohibitions that offer even more protection than some federal statutes.
Okay. Let's talk for a moment. In 2013, you wrote, and this is a quote, "I tend to agree with those who say that a justice's duty is to the Constitution, and that it's thus more legitimate for her to enforce her best understanding of the Constitution rather than a precedent she thinks clearly conflicts with it. If you are presented with a case where your view of the Constitution conflicts with Supreme Court precedent, what will control your decision? Your understanding of the Constitution or precedent?"
Senator Feinstein, I'm really glad that you brought that up, because that quote was mentioned a lot yesterday, and I'm happy to have an opportunity to explain the context. That entire article, I think that there's been some misunderstanding, perhaps because that sentence, first of all, it was citing a footnote to both an originalist scholar and a progressive constitutionalist. But the whole article was defending the Supreme Court's current doctrine, which accords constitutional precedent weaker stare decisis effect than, say, statutory precedent. And I mentioned that yesterday, against claims that we should have no doctrine of stare decisis at all, and against claims that it should be absolute and completely tie the court's hands. So I actually wasn't arguing for any alteration to stare decisis doctrine. I was saying this is how it is, this is how the Supreme Court does it, and that's right. And another couple of sentences in there, which I think might put my perspective in context, I said a new majority cannot impose its vision only with votes. It must, now I'm paraphrasing myself, it must be very sure that its interpretation of the Constitution is the right one, and that reliance, interests, et cetera, don't counsel in favor of its overruling, paraphrased. And then the next sentence was something to the effect of, an uncertainty in that regard counsels in favor of preserving the status quo. So that sentence, if it's just read alone, makes it sound like I'm arguing for the overthrow of stare decisis in constitutional cases altogether, but that wasn't the thrust of the article, quite to the contrary.
Thank you. Thank you very much. And we all welcome the fact that your family's here. It's a beautiful family.
Thank you so much.
Take care, everybody. Thanks,
Thank you,
Mr.
Senator.
Chairman.
Thank you very much. Senator Grass.